160.59, sealing of certain convictions. These are definitions. A, eligible offense means any crime defined in the laws of the state other than a sex offense. An offense in 263, a felony offense in 125, a violent felony offense, a Class A felony offense, a felony offense defined in 105 where the underlying offense is not an eligible offense, an attempt to commit an offense that is not an eligible offense if the attempt is a felony, or an offense for which registration as a sex offender is required pursuant to Article 6-C Correction Law. For the purposes of this section where the defendant is convicted of more than one eligible offense committed as part of the same criminal transaction as defined in sub 2 of section 4010 of this chapter, such offenses shall be considered one eligible offense. B. Sentencing judge shall mean the judge who pronounced sentence on the conviction under consideration, or if that judge is no longer sitting, any other judge who is sitting in the local criminal court where the judgment of, it just says in the criminal court where the conviction was entered. 1-A. The fucking chief administrator, pursuant to 10.40, shall prescribe a fucking form application which may be used by a defendant to apply for sealing pursuant to the section. It shall include all the essential elements required by this section to be included in an application for sealing. Nothing in the section shall be read to require a defendant to use such form application to apply for sealing. Okay, so there has to be a fucking form, but the defendant cannot be forced to use it. 2. Sub A. A defendant who's been convicted of up to 2 eligible offenses, but not more than 1 felony offense, may apply to the court where he was convicted for the most serious offense to have such conviction sealed. If all offenses are within the same classification, the application shall be made to the court where he was last convicted. Okay, so it's either the most serious, and if they're all the same weight, then it goes to the last conviction. B. An application shall contain 1. A copy of a certificate of disposition or similar document for any offense where he's been convicted, or an explanation of why such certificate is not available. 2. A sworn statement of defendant as to whether he has filed or intends to file any application for sealing of any other offenses. 3. This is actually triple I. It's I, double I, and triple I. Triple I, a copy of any other such application that has been filed. IV, a sworn statement as to conviction or convictions for which relief is being sought. And V, a sworn statement of the reason why the court should, in its discretion, grant the sealing, along with any supporting documents. C. A copy of any application for such sealing shall be served on the DA of the county in which the conviction of more than one or the convictions were obtained. The DA shall notify the court within 45 days if he or she objects to the sealing. When the application is filed, it shall be assigned to the sentencing judge unless more than one application is filed, in which case the application shall be assigned to the county court or Supreme Court of the county in which the criminal court is located, who shall request and receive from DCJS a fingerprint-based criminal history of the defendant, including any sealed or suppressed records. The division shall also include a criminal history report, if any, from the FBI about what happened in other jurisdictions. The court shall make this information available to DA and defendant. Sentencing judge. 3. The sentencing judge, county or Supreme Court, shall summarily deny the defendant's application when. Watch out, baby. Move over there. Thank you. Stay. Good boy. Defendant's required to register as a sex offender. B. Defendant previously got sealing of the maximum number of convictions. C. Defendant has previously obtained sealing of the maximum convictions. Isn't that fucking the same thing I just read? He got sealing of the maximum number of convictions allowable on 16058. He previously obtained sealing of the maximum number of convictions allowable under sub 4 of this section, or the time period specified in sub 5 of this section has not yet been satisfied, or E, defendant has an undisposed arrest or charge pending, or F, defendant was convicted of a crime after the date of entry of the judgment for which the last sealing for this of the last seal. What the fuck? F, the defendant was convicted of any crime after the date of entry of the last conviction for which sealing is sought. Okay. The date of the entry of the judgment of the last conviction for which sealing is sought. I think that's trying to just say that he was convicted of a crime after, you know, like he's applying to get this charge sealed, and then he gets convicted of some other crime. Okay, whatever. Or G, defendant has failed to provide the court with the required sworn statement of the reasons why he should get the relief. Or H, defendant has been convicted of two or more felonies or more than two crimes. So 2 or more felonies or 3 misdemeanors. Or 1 misdemeanor and 2 felonies, or 2 misdemeanors and 1 felony, or whatever. 2 or more felonies. So you can only have 1 felony. That's basically what that says. 1 felony, and it can't, and not more than, and only 2 crimes? More than 2 crimes. You could have 1 felony and 1 crime, or you could have 2 misdemeanors. 4, provided the application is not summarily denied, court, a defendant who stands convicted of, 4, provided that the application is not just denied for the reasons above, a defendant who's convicted of up to 2 eligible offenses may obtain sealing of no more than 2 eligible offenses, but not more than 1 felony offense. 5, any eligible offense may be sealed only after at least 10 years have passed since the imposition of sentence on the defendant's last conviction, or if the defendant was sentenced to a period of incarceration, including a period of incarceration imposed in conjunction with probation, defendant's latest release from incarceration. In calculating the 10-year period, any time he was incarcerated doesn't count. It's excluded. Such 10-year period shall be extended by a period or equal to the time served on such incarceration. So, 6. Upon determining the application is not subject to mandatory denial, and that the application is opposed by the DA, the sentencing judge or county or Supreme Court shall conduct a hearing on the application in order to consider any evidence offered by either party that would aid the sentencing judge in his decision whether to seal the records. No hearing is required if the DA does not oppose the application. 7. In considering any such application, the sentencing judge or county or Supreme Court shall consider any relevant factors, including but not limited to A, the amount of time that's elapsed since the last conviction. B, circumstances and seriousness for the defendant of the offense, including whether the arrest charge was not an eligible offense. C, the circumstances and seriousness of any other offenses for which the defendant is convicted. D, the character of the defendant, including any measures he's taken towards rehabilitation, such as participating in treatment programs, work or schooling, and participating in community service or other volunteer programs. E, any statements made by the victim of the offense for which the defendant is seeking relief. F, the impact of the sealing upon his rehabilitation and upon his successful and productive re-entry and reintegration in society. And G, the impact of sealing on the defendant's record, on public safety, and upon the public's confidence in and respect for the law. Okay, when a sentencing judge or county or Supreme Court orders sealing pursuant to the section, all official records relating to arrests, prosecutions, and convictions, including duplicates and copies on file with DCJS or any court shall be sealed and not made available to any person or public or private agency except as provided in sub 9 of this section, provided, however, that the division shall retain any fingerprints, palm prints, and photographs or digital images of the same. The clerk of such court shall immediately notify the commissioner of DCJS regarding the records that shall be sealed pursuant to the section. The clerk shall also notify any court in which the defendant has stated, pursuant to paragraph B, that he or she has filed or intends to file an application for sealing of any other eligible offense. 9. Records sealed pursuant to this section shall be made available to a defendant and his designated agent, and no, it actually says or defendant or his designated agent, qualified agencies, federal and state law enforcement when acting within scope of their duties, or anybody who's going to issue a gun license, or any prospective employer of police or peace officer. If someone applies, however, that every person that applies shall be furnished with a copy of any records and afforded to make an explanation thereto, or E, the Criminal Justice Information Services Division of the FBI, for the purpose of responding to queries to the National Instant Criminal Background Check System regarding attempts to purchase or otherwise take possession of firearms, as defined in 18 U.S. Code 18 United States Code 921 sub A sub 3. 10. A conviction is sealed pursuant to this section is included within the definition of a conviction for the purpose of any criminal proceeding when the defendant okay, so a conviction which is sealed is included within the definition of a conviction for the purpose of any criminal proceeding in which the fact that a prior conviction would enhance a penalty or is an element of the offense charged. 11. No defendant shall be required or permitted to waive eligibility for sealing pursuant to this section as part of a plea of guilty, sentence, or any agreement related to a conviction for an eligible offense, and any such waiver shall be deemed void and wholly unenforceable. Oh, that's a fucking good thing they put in there, because you know that, like, the DA would have just probably read this and been like, oh, we'll make him waive it, no problem. 16060. Effect of termination of criminal actions in favor of the accused. Upon termination of a criminal action in favor of such person, the arrest and prosecution shall be deemed a nullity, and the accused shall be restored in contemplation of law to the status he occupied before the arrest and prosecution. The arrest or prosecution shall not operate as a disqualification of any person so accused to pursue or engage in any lawful activity, occupation, profession, or calling, except where specifically required or permitted by statute or upon specific authorization of a superior court. No such person shall be required to divulge information pertaining to the arrest and prosecution.